Hey, welcome back. Welcome. In the case of Boone versus Boone, has Brian finally got the upper hand on Sarah? Let's talk about it. We have an update on Sarah. New documents have been filed. And we also have a bit of a part 2 from yesterday, Brian's response. A few people in the comments were totally confused and wanted to know the details of Brian's response. So I'll read over that document a little so that we'll have a few good quotables for the Boone farm. Nonetheless, don't forget, down below in the comment section, leave your favorite Sarah Boone related emojis or a quotable. If this is your first time hanging out on the Boone farm, we like to leave our favorite quotes from Sarah as we're hanging out on the Boone farm, just to make sure our ducks are lined up in a row. So yeah, you might wanna, or yeah, you might wanna. And then we have Sarah's response to the court, and it won't disappoint. Know that. Okay, just to get you up to speed, there was a judgment between Boone versus Boone, where Brian was ordered to pay $1,000 to Sarah for 84 months, plus $100 per month for child support. Of course, that was under the assumption that she would be a free woman taking care of the minor child. But we all know what happened on that dark night. Behind closed doors, Sarah committed a heinous act which claimed the life of George Torres and started a national frenzy. Okay, now here's the juicy part. The former housewife of Tillwood Apartments is now demanding back pay for those 5 years, upwards of $6,000. Meaning for the last 5 years, Sarah has aggressively and unapologetically pursued the monies that she feels is owed to her, even sometimes directly contacting the judge. Actually, let's rewind to the time she gave Judge Dean and the court a piece of her mind. Then former husband gets his precious attorney to file another answer-denying allegations because I'm telling the truth all the time about his awful lies and I am right. Judge Dean, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate until my trial, if and when it happens? Oh, Sarah, it's happening. However long that will be, now considering my attorney has withdrawn from my case and no date of trial is known or will be known for an undetermined amount of time. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me as his mother? Former husband is treating and reflecting a terrible example of how women can and should be treated. Nonetheless, the mother of his child. This is egregious and wrong. Please read my prior motion for a case management hearing I sent 6/28/23 with no response. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me as his mother? Former husband is treating and reflecting a terrible example of how women can and should be treated. Nonetheless, the mother of his child. This is egregious and wrong. Please read my prior motion for a case management hearing I sent 6/28/23 with no response to date. I am requesting again, please, to schedule. It is fair and there are too many topics to be discussed, including my attorney to write, and I only have one pen. Necessary, lawful, active. Important topics.
Yes.
What is the certified notice of delinquent support filed?
Why you should disregard every bit
Please
of her
grant
testimony.
my motions and schedule my imperative, overdue, owed meeting. Everyone needs and must have the same understanding now and future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated rightfully, properly, ethically correct in order to finally receive your judicial assistance? How I am and have been and will be treated by former husband Brian C. Boone is unfair, malicious, and wrong, and should not be in any way allowed to continue. Stop. Please see, please listen, please help. Okay, that was a glimpse into the mind of Sarah Boone and her aggressive, unapologetic battle for monies that she felt is owed to her, which leads us to Brian's response. Brian's attorneys pleaded to the court that equity should not punish the parent who stayed and fulfilled their responsibilities while rewarding the parent who abandoned theirs. However, former wife, Sarah, her motion seeks to do just that. She asked this court to compel the former husband to pay tens of thousands of dollars to her, despite her inability to contribute to the child's care in any way. The court should reject this request, as it upends the purpose of child support and alimony under Florida law. Now, in regards to the alimony arrearages claim, Florida law is clear that alimony is awarded based on the recipient's need and the payer's ability to pay, and an award of alimony is not appropriate when there is no need for support. As we know, the taxpayers are providing all of her basic needs: rent, utilities, groceries. She has no cost. In other words, the primary expenses alimony is designed to cover for a dependent spouse have been assumed by the government during her incarceration. Any incidental personal expenses she might have, commissary, things like that, are minimal in comparison to normal living, and they're not the responsibility of former husband. Former wife's imprisonment is an involuntary lifestyle change for the family. It was voluntary on her part in the sense that it resulted from her intentional criminal act. There we go, ladies and gentlemen. Intentional has entered the chat. I'm totally convinced that Brian or someone on his team is totally in on the joke. They have to know intentional rubs Sarah the wrong way. Florida courts consider such self-inflicted changes when evaluating support. For example, in child support context, our courts hold that an individual's actions that led to incarceration are voluntary. The former wife's need for alimony has effectively vanished since 2020. Poof. The entire premise of the original alimony award has been undermined, for she does no longer have those expenses, nor will she in the future, given her life sentence nonetheless. Continuing to enforce alimony under these conditions would serve no support purposes. It would amount to an impermissible windfall or punitive transfer of resources from the child via the sole custodial parent to the incarcerated parent. Florida law does not continuance alimony as a reward or punishment. It is purely to meet the needs of a dependent former spouse if such needs exist. Here, they don't. So then it goes on to list a little case law, Watson versus Watson, where a former husband's post-dissolution incarceration led him to seek relief from alimony due to reduced income. The third DCA invoked the clean hands doctrine to deny relief because his predicament was caused by his own voluntary acts. The court held that equity will not relieve a party of an obligation when the decrease in the former husband's financial ability to pay has been brought about by the former husband's voluntary acts. Now, while Waskin dealt with an obliger trying to avoid payment, The same equitable principle should apply on the flip side of the coin. A family court should not compel one party to continue paying alimony when the recipient's need no longer exists due to the recipient's own voluntary misconduct. All right, I hope you have your wine glasses because this is where it starts to cook up a little bit. The former wife cannot come into this court in equity and demand that her former husband shoulder a financial burden that her own actions made pointless. In summary, any claim by the former wife that she is owed alimony now is both invalid and inequitable. She has no current need for alimony support, and compelling the former husband to pay would divest resources from the minor child, effectively harming the child, to create a jailhouse bankroll for the former wife. Florida's alimony jurisprudence does not permit such an outcome. Jailhouse bankroll is definitely going into my arsenal of quotables for the Boone Farm. Definitely. In addition, the former housewife of Tillwood seeks enforcement of the $100 per month child support that the former husband was ordered to pay under the original judgment. She has a lot of nerve. That provision made sense only in the context of the parenting plan that was in place then. Once the former housewife of Tillwood was jailed and the child came to live full-time with the former husband, the entire logic of that child support arrangement was upended. From that point forward, the former husband has been the de facto custodial parent, and the former wife...
Right now I feel safe, and right now I have the ability to actually speak to you in a manner that normally I would not have the ability to.
Do you think Sarah started shaking in her boots when she read this, or did she still have some fight in her? The document goes on to say that Sarah completely defaulted on her parental obligations by doing what she did, committing that heinous act. It would be grossly unjust for the court to enforce a financial right in her favor when she has given nothing in return, and in fact has created additional burdens for the former husband and the child.
That. I don't.
Some would say that she has caused the former husband and the child so much pain, embarrassment, and hurt. You couldn't even put a price tag on it. It's ridiculous what she's requesting. Even if this court were to determine that some portion of the accrued alimony or child support technically remains enforceable, equity demands a set-off for what the former wife should have contributed but didn't to the child's care. Boom. Simple. One parent is not solely responsible for the child's care, Sarah. Even if you were out co-parenting and Brian was supporting you with child support, you would still have to support your child. Children are expensive. It goes on to say how former wife complains of an unpaid amount of $6,100, but the former husband has spent far more than that directly on the child since 2020, effectively covering both of their needs. And if the roles were reversed, she could have been obligated to pay significant child support to the former husband for the past 5 years. Now I see where Sarah gets former husband from and why it's ingrained in her. Former husband. Brian's team then continues to pull out the reverse UNO card, stating that if the court were inclined to enforce any arrearage on the original support, that the former husband respectfully requests that the court apply an offset in the full amount of the former wife's unfulfilled duty of child support or support to the child. The compelling equitable factors here include the child has been exclusively supported by one parent while the other was absent by her own doing. Any money paid to the former wife now would not go toward the child. It would likely go toward the former wife's personal commissary or other expenses unrelated to the child, and former husband has incurred all child rearing costs without any contribution. So yes, Sarah, no more cookies and cupcakes on Brian's dime. That train ended in 2020. Finally, it bears emphasizing that the child's best interest would not be served by taking money out of the household that actually raises him and funneling it into an incarcerated person who cannot use that money for the child. Florida's child support system is designed to benefit children, not enrich one parent at the other's expense. The child support belongs to the child, even though the right to receive such support on the child's behalf vests in the payee parent.
So it's been a long time.
It's probably been at least weeks, maybe.
Does Lucas play baseball or anything yet?
We've tried to get him into sports. He's not a big sports person, really.
Did you ever play baseball?
He didn't play baseball. Well, I mean, I had him like a t-ball set and stuff like that, and we'd play catch.
Is it like a plastic t-ball set, or what kind of equipment did you have?
Oh, well, this is when he was like 3 years old. It was a little plastic thing I had in the backyard.
Did you ever buy him any baseball bats or anything?
I bought one for over here that Sarah said for Lucas and George to like play with or something. That was like a year ago or something, maybe.
What kind of bat was it? Was it a wood bat?
Yeah, it was a wooden bat. I think it was like a junior size thingy. I don't know. It's something that I looked like kind of for his height or something, I think.
Okay. All right. Sorry.
Would you mind if I took a picture of your call log to show
Sure.
that you've all the
Do you just want to
attempts?
see hers, or like zoomed in on hers so you can see all those?
Yeah, that's
Okay.
perfect. So I'd say starting from today. I know her phone.
Did you text with her at all today?
Not today. I don't think I did today at all.
Sorry.
So the document goes on to proceed to not only read Sarah her rights, but explain why she comes to the court with unclean hands. Explaining and detailing how she makes inflammatory accusations against former husband, who has simply protected the child from trauma that she caused. Further, imposing fees on the former husband would likely detract from the resources available to support the minor child, again harming the innocent to reward the wrongdoer. Even if the former wife could show some need, the former husband simply does not have the financial ability to pay her attorney fees. He is a single father supporting the household on his own. Any income he earns goes to the rent, groceries, childcare, school supplies, and the like for the child. Meanwhile, the former wife's living expenses are paid by the state. In effect, former wife is asking the court to order the families to scarce money to be diverted from the child's upbringing to pay lawyers to litigate on behalf of a mother who is in prison for murder. Such an outcome would be inequitable in the extreme. Florida's fee statute is extended to ensure both parties have similar ability to secure counsel, not to oppress one party or subsidize vexatious litigation. Given the entirety of the circumstances, including former wife's egregious conduct and former husband's limited means, the only equitable result is to deny former wife's request for anything, attorney fees, cost, everything. Brian's attorneys are cooking in the kitchen like a 5-star chef. Furthermore, former husband has acted within his rights by seeking modification and by caring for the child. He has not violated any court order in bad faith, and any claim asserting that is without merit.
In these situations based on Holland 916 7 2nd 750 at point 760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of George Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of George Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when George Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent.
Couldn't believe that he could fit in the suitcase.
Did you eventually close the top?
Yes, the top was already closed. As he was settling himself in there, that's how I knew he was in there.